a JSA briefing. I know a number of us have seen the RBI's draft master directions on outsourcing of IT services. The purpose of today's conversation is just to understand what the directions indicate. And since they're draft, following at the end of the discussion and presentation, we will have a conversation about how USIBC wants to move forward. That final conversation will be off the record and we will stop the recording at that point. For the sake of everybody's time, let's just jump into this. We are super pleased today to have Sajai Singh. He's been on our platform before. He's really an eloquent and insightful lawyer. And so we so appreciate the time that you've invested to provide USIBC members a general understanding of the RBI's draft master directions and its impact on USIBC members. My understanding is that you have a presentation today and you'll roll through some slides. We will make those slides available afterwards and you may skip through some of those slides. Also, at the end of the presentation, we'll have a few questions and answers. If anybody has a question, you can either raise your hand in the application or drop it in the chat and we'll follow up and make sure that Sajai has an opportunity to respond. So with that, Sajai, over to you, sir. Thank you for your time and hopefully you can share your slides and I will go off camera until the end of your presentation. Thank you.
Thank you, Jay. And first and foremost, can you see my presentation?
Yes, we can, sir.
Yes, we can.
All right, great. So once again, good evening or good morning to the audience. It's a pleasure to be here. It's a pleasure to have this discussion with all of you. We are talking today about a document that is open for public comment. We will discuss probably post this short presentation what level of public comment or what kind of public comment would be relevant to you, since the directions are focused on regulated entities, which are basically banks and similar entities. You have till July 22nd to respond, which is not too far away. It's just one more week. So with that, let's just move on to the background. In the concept of outsourcing for the Reserve Bank of India, and the Reserve Bank of India, for those of you who may be less familiar, is our central bank. It is the regulator that regulates all, I would say, all financial institutions, but mainly all the banks, the payment service providers, and we have a NBFC, a format, which is a financial company, but it's not into the banking space. So the NBFC sector. So these are the entities that it regulates, in addition to regulating several other aspects of India's monetary policy. It has in the past not been comfortable with outsourcing. And when I say outsourcing, it's really outsourcing of services that it believed it had given the, say, a bank or another regulated entity. We call them authorized dealers because banks are authorized to deal with foreign exchange and therefore authorized dealers. So if I may use the word authorized dealer, I'm really referring to a bank or another institution that is that has been authorized to deal in foreign exchange. So the Reserve Bank was not comfortable with regulated entities trying to outsource their work, outsource their services, but it recognized that they have to. Now, these services that they were okay with the bank outsourcing were maybe incidental to the core services. So the bank did not want its core services to be outsourced, or the Reserve Bank didn't want banks to outsource their core services. but they could outsource services that may not have been core. We'll come to that in a minute, but that was generally the thinking of the Reserve Bank. It never really spoke about IT services. So these were the existing regulations which are listed in front of you. The guidelines for outsourcing, for IT outsourcing, this really comes from limited, I would say, provisions that we could find in the security and security, electronic banking, technology risk management, and cyber frauds guidelines. Were really talking about diligence, that you be careful when you outsource IT services. It didn't really get into too much detail, and that's the detail we find in the master directions. Financial services outsourcing, as I'd said, they were not very comfortable with outsourcing of core and related functions. But yes, if there was something which wasn't core, then that was okay. So some core decisions are mentioned here, like opening of an account, disbursement of loans, a management of investment portfolios. These, the Reserve Bank was not comfortable being outsourced. But other services could be, including, things like housekeeping and janitorial, security, and all those other things. The outsourcing arrangements that the Reserve Bank now is talking about are based, or the directions that the Reserve Bank is talking about are based on a very, very basic premise, which is that the regulated entity will have obligations towards its customers. So, if it was to outsource an IT service, its obligations to its customers will not change. So if something does go wrong, it is the regulated entity which will be liable. Additionally, there is expectation that the Reserve Bank be allowed to supervise or audit or access or be involved if something was to go wrong, or maybe just otherwise a sanitary check. So these are some of the fundamental premises on which seem to be well, I would say one was obvious and the other seems to be, in a manner of speaking, new. But these are what are the basis of the master directions. There is a concept of materiality. These directions, the master directions, really apply to material outsourcing arrangements and not to things that may be non-material. Materiality has been described here. Again, pretty obvious that something that affects the regulated entity's reputation, operations, profitability, or an unauthorized access could have a material impact on the customers of the regulated entity. So these are the outsourcing arrangements that the master directions really address or are focused on. These are the regulated entities. I will skip through all of those because you will get these slides and you can have a look at them at your leisure. Now, I think many of you in the audience may fall within what may be called service providers to regulated entities. I doubt you have too many regulated entities on this call. So wherever I have a slide on service providers, I will try and stop for a little longer, trying to keep time. So it's in general, the service providers who have the expertise, and again, the Reserve Bank does expect the regulated entity to check the background. Service providers who have the expertise may take on IT infrastructure on behalf of a regulated entity. It is in terms of the outsourcing of IT services. There's a definition that has been provided. The regulated entity's use of somebody else's, the service provider's services to perform an activity on a continuing basis. Now, continuing basis should not be read as perpetuity. It could be for a certain period of time. These are housekeeping things that the regulated entity should have a policy. Why this is relevant is that if you are servicing a regulated entity, you should really, and this goes through, you should really be asking for the policy of the regulated entity, because you should be aware that if the regulated entity has that policy, then that policy, the Reserve Bank will be aware of that policy, and you may be expected to comply with it. Grievance redressal, very important. The service provider, this particular provision really is with regard to the quality of services and the standard of care that you exercise for the work of a regulated entity. It is expected that you would do this as good as you have been doing it for other entities, and as well as the regulated entity would have done it if it was doing it in-house. There's a whole concept of evaluation of service providers. And again, if you are going to be providing services to a regulated entity, then be aware that there will be a diligence that will be conducted. And 4 factors that will definitely be considered would be your past experience and competence, financial soundness and capability, if you have a conflict of interest. And this keeps coming back a few times because the Reserve Bank is cognizant of the fact that that service providers may provide the same service to different regulated entities in India and overseas, and therefore, are they taking care of segregating the work, the data, everything else between its customers? So these are some of the things you should be ready for if you are pitching to a regulated entity. Key provisions of outsourcing agreement. I don't think I have to take you through this because you would be pretty aware of this, and you can read through when you get the slide deck. Then comes risk management. The risk management, the basic idea is that the regulated entity is responsible to its customers. And at the end of the day, it's the liability of the regulated entity vis-a-vis the Reserve Bank of India. And if it was to outsource services, then it should ensure that it gets back-to-back protection. I mean, again, many things are pretty obvious, but this is something that the Reserve Bank is guiding regulated entities with. The integrity, the confidentiality of how a service provider deals with the regulated entity. All of these are very important to bear in mind in terms of providing the service. In terms of the interesting thing, which is different from other provisions, which is the CERT provisions, should there be a cyber incident or a disruption in service, then the service provider should inform the regulated entity very, very fast. It's just an hour that the service provider has to inform the Reserve Bank. In terms of assessment of risk, again, the Reserve Bank points out that it's possible that the same service provider is providing the same service to many people, or one regulated entity may have outsourced all its IT services to one service provider. So it's just guiding the regulated entity in terms of how it could best manage risk. Business continuity plan and disaster recovery plan. Again, all of this, there has been direction on this, and probably soon we will have a master direction again for public comment, which the Reserve Bank will release. So we can, wait for that and have a look at that. Monitoring and controlling. The expectation, I would say, from a service provider's perspective will be that there will be an obligation on your customer from the Reserve Bank to constantly monitor performance, service availability, adherence to the terms, the agreed terms. So audits and various other compliances will be expected. Yes, global certifications are going to be accepted in India. But having said that, it's important to be aware of the scrutiny, ongoing scrutiny, should you decide to provide services to a regulated entity in India. There is no restriction or no requirement to only outsource in India. Outsourcing can happen anywhere. There is an expectation that the Reserve Bank will have, as I said, would be able to conduct an audit or inspection of the service provider. But other than that, it's pretty open that the outsourcing can be anywhere in the world. There has to be some level of compliance, of course, but in general, there is no restriction that the outsourcing has to be domestic. Exiting of an outsourcing arrangement, interestingly, has been the Reserve Bank has spent a little time on that and provided a lot of guidance on that, and why and when you can exit. I guess these are provisions that would find their way into an outsourcing arrangement in any case, but these are further highlighted by the Reserve Bank, expecting the regulated entity to have very detailed exit arrangements with service providers. So again, expect a lot of discussion on this, expect a bit of negotiation on this when you're negotiating your next outsourcing agreement with a regulated entity. The Reserve Bank is saying that you may already have an arrangement. All we ask is that you revise it or bring it in line with the notified. They haven't been notified yet. The notified directions whenever that happens. Cloud computing services, again, the Reserve Bank recognizes that banks and various other regulated entities do need that, and therefore has separate provisions on that. I guess these provisions will be important to review by the colleagues who are on this call, to have these reviewed from your commercial teams. I'm sure all of what is written there, whether it's a business continuity plan or transition of services, audit requirements. I'm sure all of this is already factored into your cloud computing services that you offer regulated entities. But again, if not, you may like to review this. And as we go into the discussion in terms of comments that you may offer to the Reserve Bank, you may like to see if there's something onerous expected from you over here. A SOC operations being outsourced, the Reserve Bank would like the regulated entity to be sure of the owners of the assets that in the SOC services that are being provided, be it the source code, programs, hardware. So it's very important. Again, all of this is more from a diligence perspective, and the Reserve Bank would like the banks and the regulated entities to be aware of where the SOC is, who owns it, where its customer data may find its way. So all of this is just, again, it's just to direct the attention of the of the regulated entity to be mindful of very important issues relating to probable disruption, customer data, and like issues. Thank you. I think that would be all that I had to say. I'll just check with Jay, if I'm within time or how?
You're spot on, sir. Thank you. If you can stop sharing your screen and we will then highlight you. And if there's any questions, now would be a good time to raise your hand or ask a chat. I did read through the directions and I do have an initial question while we're waiting for our members. Hopefully this will stimulate other conversations. I saw maybe something of conflict, right? You saw some requirements for localization, and then you also saw some requirements for business continuity. That might be at contest if in a particular situation, if there's a large internet outage in India, right, and then the business continuity would be to move out of India and have some sort of backup in another geography, which is very common. How does the direction sort of handle that scenario, right? Required localization, but then if you want business continuity, you may have a requirement to not be localized or have mirrors or have the ability to move information.
So there isn't a localization requirement for IT services, Jay. The one thing that the master direction doesn't do is specify that anything has to be local. It recognizes that the services that they are talking about, material IT services that a bank would need, it's possible that they can't be provided in India. So I think the assumption is that it will be cross-border. I'm not saying it has to be, but the assumption with which they are written is that it's cross-border. So therefore, transition of services between one service provider to the other or between two locations of the same service provider are totally fine. It's just the expectation that the Reserve Bank has that a regulated entity who is getting into an outsourcing arrangement is aware of all this, ensures that all these things are covered either, of course, in the outsourcing arrangement, but also in due process. Because a lot of the audit is not, I mean, you just don't write it in the outsourcing arrangement, that's fine. You have to actually implement it. So there has to be a procedure and protocol that you follow through. And that's what the Reserve Bank, I think, is trying to say, that it's not just the agreement you sign, it's the process that you thereafter follow and the diligence that you do pre signing the arrangement. So those are the focus areas. In terms of the conflict, the issue is really the fact the Reserve Bank recognizes that one service provider is not solely or exclusively providing that service to one bank. And if you are going to provide a similar service to other banks, what are the safeguards that you have? And that's what the Reserve Bank is pointing out to. It's highlighting the potential of conflict. It's highlighting the potential of similar data being there or confidential data being available at the same service provider, which will be extremely valuable to another customer of the same service provider. And how are you dealing with that? Are you putting in enough confidentiality provisions? Are you putting in strictures? How are you doing that? That's what the Reserve Bank is trying to direct the attention of the regulated entities. So I found that I would say more a recognition of reality by the Reserve Bank than anything else, and which is really good because um, whoever wrote this within the Reserve Bank did apply their mind to ground realities of outsourcing and service provider, the scope of business of a service provider.
Thank you. Nalima Pagankar, did you have a question?
I did, thank you. Let me see if I can get myself. Sajay, thank you for that. Question I have is the directions also address outsourcing relationships with related parties and entities within the group or parent companies. Could you talk a little bit about realistically what they're looking at in terms of the contractual arrangements and the need to ensure that the arrangements would be at par if it were an open bid?
So I think the idea basically is that there is no prohibition, um, per se. I think what's the RBI is really focused on an arm's length transaction. It's it's not suggesting, or it's the strictures are not there as yet. I mean, these are really guidance notes for public comment. Obviously, we'll get into the details later, but what it's trying to do or establish over here is the fact that even if you're a related party, I mean, of course, it is obvious that you would need to act on an arm's length basis, but it's just making the regulated entity aware that be it conflict of interest because of the party being related, be it conflict of interest um, if the entity is servicing more than one customer, be it conflict of interest or be it a very risky situation where one regulated entity provides only or uses only one service provider for all its IT needs rather than distributing its services to others, to different service providers and edging its risk. It's really asking for public comment and seeking inputs from the public, and here in this particular case, service providers. So with regard to regulated entities, so long as the relationship is on an arm's length, the Reserve Bank should be okay with it. If it was something where a third party was to bid for those services and the third party was to provide those services, would that be similar to the services that a related party would provide? If the regulated entity was to do the services entirely themselves, would the services of the service provider be similar to this? So those are the provisions that it has mentioned right now. But the prohibitions either, or the requirement for localization or prohibitions for related parties are not there as one sees in several other similar, I would say, documents for public comment.
Thank you, sir. Any final questions or comments from our members? I have one final question for you, sir, and then we will wrap and move to the non-public portion of this conversation. Overall, a lot of our activities focus on the ease of doing business versus very complex regulatory oversight, paperwork, audits, and so on. What's your opinion about these directions? Are they balanced? Are they heavy regulation? Is it a light touch regulation? Is it requiring a lot of new work, new activities, or is it codifying a lot of things that going on? Just your general impressions of these draft directions.
I don't think it's over-regulation. I think, as I mentioned earlier, I think whoever wrote it knows the business and actually took into consideration all aspects of the business. Of course, risk mitigation is highlighted, but they took into consideration how a service provider functions and the need of the regulated entity to provide, to outsource IT services. So in that sense, I think it's someone who has recognized this issue and trying to just more guide regulated entities than anything else for something that they hadn't done before. Outsourcing of IT services, outsourcing of services they had done, banking related services, which were non-core, but they hadn't done this. So in that sense, I don't think it's over-regulation. However, the provision for audit and the requirement for access of the Reserve Bank to the service provider may, and I'm not, I mean, it'll really be the industry and the service providers on this call who will comment, may be considered by some as, I won't say onerous, but a little bit of restructuring of the business proposition today.
Okay, thank you. Is there any provision for grandfathering? Because people have, many of these contracts are long-term, or would companies and entities need to kind of redo their contracts because of this?
So, very good question, Jay. You would need to redo, but I was just talking to a client recently on this, and I was just saying that you probably have exactly the same provisions in your agreements, other than the sort of Reserve Bank access or a few other 2 or 3 other points. I don't believe you really need to redo the whole agreement. There may be, yes, there may be tweaks. So, but yes, you will need to, if they are notified ever.
Thank you. Well, with that, with no further questions, sir, I want to thank you for your insight on this. As I said, we will share the slides with our members, which include your contact information for follow-up. And so we are ending the recorded portion of our webinar. And thank you all for joining.
Thank you.